Thank you very much. May I quickly introduce myself? My name is Oliver Stockel. I work for the German law firm von Bötticher. We are for German standards mid-sized law firm with 25 lawyers. We are headquartered in Munich in Germany, and we have also offices in Berlin and in Frankfurt. IP and IT law is one of the main pillars of our practice, and today I will be speaking about IP litigation in Europe. So, could you please put it on the screen? Okay. Oh, it's low. Well, okay. Low in memory. Click that away. Okay. So the topics of my speech, as a quick overview, first I will talk briefly about the general principles of IP litigation in Europe, particularly about the international competence of the courts and the different legal venues in the European Union. From that, passing on to the strategic choice of the right legal venue for litigation if you have a choice. Then I will switch over from a claimant's perspective to a defendant's perspective, talking about defensive strategies in the various jurisdictions and venues. And then I will switch on to the topic that probably mostly interests you, which is how can I stop infringement quickly, which means how do I get an injunction in Europe. And in order to make it not too theoretically, I will close with a short case study, a case you may be familiar with. It's Apple versus Samsung, the usual suspects, a case which was tried in the Düsseldorf courts for design right infringement by Samsung's Galaxy Tab. So first of all, some of the general principles of IP litigation in Europe. Concerning the procedures, the procedural rules, we don't have very much unification throughout Europe yet. I mean, there's the EU regulation number 44/2001 as amended, which basically regulates the international competence of courts within the EU, the mutual recognition of court decisions among the member states, and certain common principles of delivery of briefs and of court actions within the EU. But it's basically done with that. When you actually look how the procedures are run in the individual courts, we have altogether 28 different procedural sets of rules, as each member state still applies its own rules. So although some widespread principles apply more or less in all member states, they are pretty much down to what is in common to all jurisdictions. Of course, you have to initiate court action by local counsel. Many jurisdictions require payment of court fees up front, and in some member states you will find that the losing party will have to reimburse the winning party for some of the, at least some of the procedural costs. What is also common to most of the jurisdictions in Europe is that we have no discovery proceedings. So any claimant filing a claim in the European court should be sure of his case before the actual filing and should not rely on gathering the necessary evidence in the course of the proceedings. All member states basically offer injunctions, particularly in IP matters, but again, the rules according to which injunctions are granted or rejected are different in each member state. So again, there you have the 28 different sets of rules. When we're talking about international competence of the courts in the European Union, we have to differentiate between two main areas. First, the community IP rights and the national IP rights. When you talk about community IP rights, like the community trademarks and the community design rights, there's the general rule that each court in the European Union may issue a ruling that is valid and enforceable throughout the European Union. This is based on the ECJ case, DHL versus Chronopost. So in this case, you can go, if you want to, for a one-stop shop in one legal venue that's available in a member state of your choice in the European Union, and can obtain a ruling there which will be valid and enforceable throughout the European Union, again, through regulation number 44/2001. In most legal venues, you will also be able to do that in injunction proceedings, particularly in Germany, that's true. As for non-community IP rights, like national trademarks, national design rights, national patents, and so on, you have to rely on a state-by-state litigation basis. So in case of a multinational infringement within Europe, you have to go to the individual courts in the individual member states, have to coordinate the multinational litigation in these states. And the only harmonization you will find within the European Union there, again, is that the individual rulings you will get in the member states are mutually recognized and can be delivered in accordance with Regulation number 44/2001. So when it comes down to actually selecting the right venue in the European Union, where can you go to court as a claimant? You should keep in mind that as a general rule, you can always select a venue where the residence of the opponent is. And also you can usually go to court where infringement took place. So these are two general principles that widely apply. In some countries, you will also have a legal venue if there is a certain link to that country. So, for example, again in Germany, if the infringing goods are offered on a website that is addressed to German consumers or customers, but you cannot prove a sale in Germany, that will be sufficient because it's an offer that is addressed to German customers, and that will be sufficient to create a legal venue in Germany. So when you finally see that you have several legal venues available, you have to make a strategic choice which legal venue to take. So the aspects you should be taking into account are the usual ones. So you should think about processing times, the competence and the reputation of the the courts that you probably can go to, the international recognition of their rulings, injunction options, procedural pros and cons, the effectiveness of the court handling the procedure, and of course cost efficiency. Language is decreasing as a problem, particularly in Germany. So if you go to the commercial courts in Munich, for example, they will widely accept English exhibits without demanding a translation because they say, we are commercial judges, English is the commercial language, we speak English, so we'll accept English exhibits. So that's becoming less and less a problem with increasing language knowledge in Europe, although the proceedings themselves will be in German or in Italy and French in the respective languages in that country. Now, switching over from the claimant to the defendant's position. So the defendant obviously can't choose the legal venue. So what can the defendant do, or how can the defendant make use of the various jurisdictions in the European Union? So first of all, the defendant should have a look at the venue, at its particularities, get in touch with local counsel, do risk assessment, find out about the pros and cons of the procedural rules of that particular jurisdiction, and work out a defensive strategy together with the local counsel. So that's what you would basically do in every jurisdiction. There's one particularity about the European Union is the so-called torpedo. What it actually means is if you know that an attack based on an IP right is about to come from one of your competitors, for example, you can go ahead and search a jurisdiction or legal venue in which the courts are known to be slow, like Italy, for example, and you make a filing for a negative declaration that there is no IP infringement. And this, under certain requirements, such a filing may block an active action of the IP owner in another member state, and so this is a defensive strategy where you can make use of the provisions of EU Regulation number 44/2001 in order to defend yourself against active strategies of the IP owner. So moving on to injunctions, how do you quickly stop IP infringements in Europe? Basically, the IP Enforcement Directive introduced by the European Commission introduced obligatory injunctions in case of IP infringement with certain minimum requirements for all member states. So you will find injunctions with certain minimum provisions in all member states based on that directive, but only the fact that these injunctions are available is harmonized. Again, the rules, the procedural rules under which you can get an injunction are mainly subject to the national procedural rules of the individual member states. So therefore, you should, when you think about getting an injunction in Europe, explore quickly with local counsel the options and the requirements of injunctions in Europe, particularly as for injunctions in Europe, very strict deadlines may apply and you lose your options if you don't do that quickly. No. Just get that away. Okay. So also keep in mind that in some jurisdictions it is customary or sometimes even required to send a cease and desist letter before you go to court. Also this you should keep in mind before going to court in any of the member states. So I'll give a quick example of injunction proceedings in Europe as, at the example of the German procedural system. First of all, if you want to have an injunction in Germany, you have to keep in mind that you have to demonstrate urgency of the matter. So, as a basic rule, you can keep in mind if between first knowledge of the infringement and filing of the application more than 1 month has passed, you generally lose your urgency and you won't get an injunction. Furthermore, German courts will usually expect you, unless it's obvious counterfeiting, that you have sent a cease and desist letter allowing the defendant to voice his objections or his counter-arguments as to the IP infringement. Once you have taken these hurdles, you usually get your injunctions quite quickly, within 1 to 3 days, and they're usually granted ex parte. So this is actually a standard in IP matters. And they are equally quickly delivered to the opponent. If the opponent is represented by counsel, you can even do the delivery by fax. And one other particularity we have about the enforcement, what basically each member state has, if the defendant doesn't adhere to the injunction, a fine can be imposed by the court. But what we actually have as a particularity is if there's repeated non-compliance with the injunction, the court can actually order the imprisonment of the company director to enforce the injunction. And so far I haven't seen a company director willing to go into jail for his company. Another point is that, at least in Germany, injunction proceedings are usually very cost effective. Filings can be done quickly. You don't have to write that much for the court. You don't have to evaluate that much of evidence. And usually applying and getting an injunction can be done in an average trademark case, for example, for less than 10,000 euros. Now, so far to the theory. Let's put this into practice. And I've picked a case that was tried in the Düsseldorf courts. And this particular case is interesting because it was completely tried in injunction proceedings and with an EU-wide effect, as Apple invoked a community design right in this case. So I've quickly summarized the main facts of the case. Apple claimed that Samsung's Galaxy Tab infringed upon its community right for tablet PCs, the community design right. Apple claimed to have learned of the infringement on 18th July 2011, and they filed an application for injunction against Samsung Korea and the German Samsung subsidiary with effect for the whole of the EU, basically without Netherlands, there's been an exception there, on the 4th of August 2011, so within this 1 month deadline. Apple argued that Samsung Germany was a mere sales subsidiary of Samsung Korea, and thus any infringement offers of Samsung Germany should be attributed also directly to Samsung Korea. The court decided 5 days later, there was a weekend in between, granting the injunction ex parte on 9th August 2011. Samsung Korea and Samsung Germany were sentenced to stop any offers or sale of the Galaxy Tab in the whole of the EU with an ex parte injunction. Okay. It's not working anymore. Okay, I'll try this one. Stick is not working. No. It's at the end of the slideshow.
Yes.
Oh, sorry, the remaining, as it says the computer has not enough memory and cannot display the remaining slides. Can we somehow resolve this problem, please? Because I actually have to rely on those slides. I don't have it all in my head. Because there's some more
1 second.
slides.
Just
Yeah.
1 second. I'll remove the old ones.
Don't worry.
These are ours.
Yeah.
This is old. We are on slide number. Charge out.
Slight technical problems.
We are on slide 1.
Just and then.